All right, we kick off the third hour of the Elias Macko Show, taking a look at the new proposed online harms bill. Now, it would give the Justice Minister the power to impose house arrest on someone who is, quote, feared to commit a hate crime in the future, even if they have not done so already. That's how the Globe and Mail puts it last week. Justice Minister and Attorney General Arif Virani is defending this part of the bill. But is this okay? Let's get the thoughts of one criminal defense attorney. Eric Sutton joins us on the line. Eric, welcome back to the show.
Thank you. Thank you for having me.
Well, let's start off with this one, right? People are calling it very much pre-crime Minority Report-esque. How do you view this part of the online harms bill?
Well, I agree with some of the concern that's being voiced in the legal community and by the media, because it's giving the state the power to criminalize potential misconduct with very severe restrictions. It really is much like being sentenced for having committed a criminal offense, whereas what we're saying is we fear someone will commit a hate crime without that person actually having done anything that's criminal. It's disturbing. For me, it's disturbing. You're giving the state enormous preventive powers, and you're sort of navigating in very uncertain waters. You really are just speculating. There has to be good reason to your speculation, but it really comes down to a form of a speculative process to determine if the potential misconduct is established.
So, Eric, the state does have fantastic powers, one would say. Is there anything similar to this that's already in place for a different type of crime or a different type of offense? Is there anything that comes close to this already in Canadian law?
Well, there is, in the sense that under Section 810 of the Criminal Code, and there are other sections that follow, one can go to the police with seeking what's called a restraining order or a peace bond. That's how it's known sort of colloquially. It's under the criminal code where you reasonably fear that someone could harm you or damage your property. And on that basis, if there's a hearing and that fear is seen as reasonable, that person can be ordered to respect certain conditions for a year. They can be quite restrictive. So the concept is not unknown, but now we're getting into hate crime, which tends to be verbal advocacy, and the fear that someone will likely commit a hate crime. It becomes much less tangible and harder, in my opinion, to prove.
One of the things I've also heard mentioned when it comes to this bill, and it was the Justice Minister himself, Arif Virani, was asked about, well, who gets to decide what hate speech is in the context of this bill? And he said, well, it will be up to the courts. Do you view that as a good thing, or do you view it as a bad thing? In my mind, if it's up to the courts, that means the goal lines can be moved any day, any week by a different judge. How do you view that aspect?
Well, a judge will have to determine if there's evidence that supports a finding that one can reasonably fear that someone will advocate hatred towards a identifiable group, be it because of their ethnicity or religion or gender orientation or what have you. So I think that it's not a bad thing that it's left to the courts, and the courts establish jurisprudence. They establish standards that have to be met, and I don't think it's a bad thing that's left in the hands of the courts. But we have to bear in mind that hatred itself is so ill-defined. I mean, under this new proposed legislation, showing disdain for a identifiable group doesn't meet the definition of hatred. Disdain does not. Detestation does. And it's left to an unfortunate judge to have to distinguish between what's disdainful and what qualifies as detestation. It's such a fine line and a dangerous line to cross, because once you cross it, you can impose very, very egregious conditions on someone just on this finding that they that they will commit a crime when they have not, in fact, done so.
We're with criminal defense attorney Eric Sutton talking about the proposed online harms bill. And one of the things, Eric, that I've heard criticism of this bill is that it might not be that necessary. Like there's all types of things that are already illegal, So, being a predator towards young people, already illegal, yet it's in this bill. Advocating for genocide, already illegal. We don't need a new online harms bill for that to be illegal. So on that end, is some of this bill just regurgitating what was already illegal, and is there any benefit to that?
I agree. It doesn't really add that the powers to intervene are already there if someone is in danger, be it a child or you're quite right. These legislative proposals are often politically motivated. There are lobby groups who put great pressure on the government. The government is concerned about the reputation and getting votes. And then they come out with this sweeping legislation that they think will show everyone that they're acting responsibly and they're concerned about public safety. And it becomes basically a political initiative that essentially you might wonder just how effective it's going to be or how useful it is when the state already has enormous powers to intervene if there really is a perceived harm to any person. As I mentioned, the power to obtain a peace bond has been there for a long, long time, and the police can respond to a legitimate complaint and intervene. Now we've just spread our wings a bit too wide, in my opinion, and I'm not sure that it's necessary, and I think it could be dangerous because we are criminalizing potential misconduct.
And just on the other end, have there been any instances in your role as an attorney where you've said, "Oh, golly gee, I wish we had more clarification, tougher laws"? Are there any things where you feel, "Hey, we need some clarification. The laws are too ambiguous, and some clarity would help actually when it comes to the online space"?
Well, it's a good question. I mean, I think we'll see whether this legislation, if it does pass, doesn't lead to courts just, struggling to determine whether a person has been advocating hatred towards an identified group. I think courts will struggle, and then there'll be appeals, and we'll be going to the Supreme Court to try and provide that clarity. And what we have really is a social problem. There's no question. There's tremendous amounts of hatred that's unfortunately part of our culture. And there are people who, unfortunately, are very popular who advocate hatred. And who do you blame? Do you blame the person who's communicating it or their followers? And there can be thousands. So is legislation really going to change that? No, there's a social problem. So a legislative solution may sound good, but it may not really change much until we get to the root of the problem, which is really social and education. And we all have to take responsibility to make ourselves a little more humane in our manner of living and thinking.
And Eric, just what you brought up there about how these cases, they'll get appealed and they'll be appealed again and they'll end up in front of the Supreme Court. It is not lost on me that very recently the Supreme Court, it was a 5-4 decision, the Mike Ward comedy case, 5-4. Yes. So I just wonder how the Supreme Court will handle, offensive speech, right? If they came down to 5-4 split decision on comedy, what will they do with stuff that is, with borders on hate? Tricky stuff indeed. Eric, we do have to leave it there. Thanks so much.
All right. Thank you for having me.
Criminal defense attorney Eric Sutton with his take.